Hey guys, welcome back. Tonight we're diving into something that might seem boring on the surface, but trust me, it's absolutely fascinating. We're talking about how Romans settled disputes, and I mean really settled them, without any of the fancy technology we take for granted today. No cameras, no recordings, no written contracts that hold up in every situation. Just people, arguments, and some incredibly clever systems that somehow worked for an entire empire. Before you scroll away thinking this is going to be dry and full of Latin legal terms, stick with me for just a second. Because what we're about to explore is actually a masterclass in human problem solving, psychology, and the art of making people believe you when you have nothing but your word and your reputation on the line. The Romans faced the same disputes you deal with today: property arguments, business disagreements, personal grievances, accusations of theft and dishonesty. The difference is, they had to solve them without lawyers as we know them, without court recordings, without the ability to subpoena documents or pull up security footage. So how did they do it? How did a Roman magistrate or praetor stand in the forum, listen to two angry people pointing fingers at each other, and actually figure out who was telling the truth? That's the real story tonight. If you're into history, psychology, or just how humans get creative when they're backed into a corner, this one's for you. So grab a drink, get comfortable, and let's step back in time to ancient Rome, where settling a dispute was as much about theater as it was about justice. Imagine you're standing in the Roman Forum, the marketplace and center of civic life in ancient Rome. It's probably a hot day, crowds milling about, vendors shouting, people conducting business. Two men step forward, and they're furious with each other. One claims the other owes him money. The other says he already paid. There's no receipt. There's no bank record. There's no way to definitively prove what actually happened except through their word and whatever evidence they can dig up. A magistrate, a Roman official, watches from an elevated platform. Maybe he's a praetor, a high-ranking judge with real authority. Maybe he's a lower-ranking aedile. Either way, he's the one who has to make a decision that will affect both of these men's lives and reputations. And here's where it gets interesting. The Roman legal system, especially in its earlier forms, wasn't primarily about finding absolute truth in the way modern courts try to do. It was about creating a process that felt fair enough that people would accept the decision, even if they didn't completely believe it was right. It was theater, yes, but theater with real consequences. The first thing the magistrate does is listen. And I mean really listen. Both men get to speak, often passionately, often emotionally. They tell their side of the story. They present any witnesses they have. They bring forward anyone who might corroborate their version of events. The magistrate watches their faces, hears the tone of their voices, observes their body language. In a world without lie detectors or forensic evidence, human judgment had to fill in the gaps. An experienced magistrate could tell a lot from how a man carried himself when he was under pressure. Did he hesitate? Did he become defensive? Did his story hold together under scrutiny, or did it fall apart when questioned? This was basic human psychology, the kind that predates by thousands of years any formal study of how people behave under stress. But listening was just the beginning. The magistrate would often ask probing questions, sometimes seemingly innocuous, sometimes directly challenging a man's version of events. If someone claimed they paid a debt, the magistrate might ask when, where, to whom specifically, whether there were witnesses. He might ask about other similar transactions, about the relationship between the two men, about whether this had happened before. The accumulation of details, the consistency or inconsistency of the story being told, all of this painted a picture. Sometimes, if the magistrate felt he needed more information, he could call for witnesses. And here's where Roman society's obsession with reputation and honor came into play. A witness who lied in court, if discovered, faced serious social consequences. His reputation would be destroyed. His word would be worthless for all future dealings. In a society where business and honor depended entirely on being known as someone who told the truth, that was a devastating punishment. So witnesses had a powerful incentive to be truthful. Of course, that didn't mean all witnesses were honest, or that powerful men couldn't pressure weaker ones into lying. But the system created at least some incentive toward truthfulness. If the case involved a debt or financial disagreement, the magistrate might examine documents. A contract written on papyrus, a will, a record in a ledger. Romans loved documentation, even though it wasn't always accessible to everyone. The quality of the handwriting, the way the document was sealed or witnessed, whether it had been properly registered with authorities, all of this mattered. A document that looked hastily written, that had signs of tampering, that lacked proper witnesses, carried less weight than one that bore all the hallmarks of authenticity. The magistrate had to use judgment and experience to determine what documents were credible. Then there was the oath. By Jupiter or by another god, a man would swear to the truth of his version of events. In theory, this was terrifying. Perjure yourself before the gods, and divine punishment would follow. You'd anger the gods, bring bad luck on yourself and your family, curse your line for generations. In practice, it was a psychological lever. A man taking a sacred oath had to be aware that he was making a claim so serious, so important, that he was willing to risk the wrath of the heavens for it. That conviction in his own testimony, or lack thereof, showed. A weak, hesitant oath might make the magistrate doubt the man's sincerity. A confident oath, combined with consistent testimony and corroborating evidence, became persuasive. But what happened when two equally convincing claims collided? What if both men seemed to be telling the truth, but their stories contradicted each other? Rome had a solution for that too, and it was surprisingly sophisticated. Sometimes a magistrate would call for what's called compurgation, or oath helpers. If a man couldn't prove his claim through documents or witnesses, he could ask friends or associates to swear alongside him, affirming the truth of his claim. The more people willing to stake their own credibility on a man's story, the more credible that story became. Because if compurgation failed, if not enough people were willing to swear for him, it suggested his claim wasn't convincing, even to those who knew him well. On the surface, this seems ripe for abuse. Couldn't a rich man just pay people to swear for him? In theory, yes. In practice, Rome's community was smaller than you might think. Everyone knew everyone. If a man suddenly got a bunch of strangers to swear for him, it would look suspicious. The magistrate would notice. And if someone repeatedly swore falsely, his reputation would eventually catch up with him. He'd become known as someone who could be bribed, whose oath meant nothing, and his usefulness to others would evaporate. The system relied on the fact that reputation was worth more than money in the long term. A short-term bribe might get you a false oath, but it would cost you every future profitable relationship you might have had. Now let me tell you about a specific type of dispute that the Romans had to solve constantly, arguments over property boundaries. Imagine two landowners fighting about where their property lines actually are. There's no GPS. There's no official survey that's been updated recently. Both men claim a strip of land belongs to them. Both point to old documents. Both cite whatever memory they have of where their fathers said the boundary was. A magistrate couldn't just guess. He had to actually go to the property and assess the situation himself. So he'd do what Romans called an inspection. He'd walk the land with both parties present, look at natural features like streams or rocks that might mark a boundary, examine any walls or fences, and listen to both men's arguments about what they thought the evidence showed. Often there were physical clues, an old stone wall that had been in place for decades, a particular tree that had been used as a landmark for generations, a stream that had been recognized as a boundary in documents that weren't being disputed. The magistrate had to interpret these clues like an archaeologist, making educated guesses about what they meant based on context and logic. Sometimes, if the evidence was ambiguous, the magistrate might make a decision based on possession. If one man had been using and maintaining the disputed land for years, if he'd been collecting crops from it or building structures on it, his claim was stronger than a man who had let it sit untouched. Possession, especially long-term possession, suggested ownership in Roman law. The Romans were pragmatists. They understood that in the absence of perfect evidence, the person who had actually invested in the land, who had made it productive, had a stronger claim than someone who just pointed to an old document and hoped for the best. Another common type of dispute involved contracts and agreements between merchants or craftsmen. A builder might claim he wasn't fully paid for constructing a man's house. The homeowner might claim the work was shoddy and didn't deserve full payment. No written contract detailed every aspect of what was supposed to be done. They'd made an agreement, probably fairly informal, and now they disagreed about whether it had been fulfilled. The magistrate would have to examine the actual structure. Were the walls sound? Was the roof properly built? Did the builder use good quality materials or cheap ones? He might consult with other builders, experienced men who could assess the work and say whether it met the reasonable standards of the day. Then he'd listen to both sides explain what was supposed to happen, what actually happened, and why they thought they were right. The decision would come down to judgment, experience, and an assessment of which version of the truth seemed most likely given all the available evidence. Sometimes the magistrate would split the difference, ordering partial payment if he thought the work was incomplete but not entirely fraudulent. This wasn't about perfect justice. It was about finding a resolution that both parties could accept as reasonably fair, even if neither was entirely satisfied. The beauty of the Roman system, at least in its better moments, was that it created a process that felt legitimate, even without modern forensic tools. People believed in the system because it allowed them to present their case, because it used people they recognized as authoritative, because it involved oaths and witnesses and community involvement. People are willing to accept a decision they disagree with if they believe the process that led to it was fair. That was the real power of Roman dispute settlement. It wasn't that it always found the truth. It was that it created a framework where people felt heard and the decision seemed legitimate. Now let's talk about something even more interesting. The rare occasions when the evidence was so ambiguous, when both sides had such equally convincing claims, that a magistrate had to find a creative solution. These moments reveal how deeply Romans understood human nature, and how sometimes the best way to solve a dispute isn't through evidence at all, but through a test that forces truth to reveal itself. Imagine this. Two men claim to own a single cloak. Both have witnesses who say they've seen them with it. Both claim the other stole it. There's no documentation, no obvious signs of ownership. A magistrate in this situation might take an unusual approach. he'd propose a test, something that would put psychological pressure on both men and make the truth more likely to emerge. One famous method was called the ordeal. Now, before you think we're talking about something barbaric, remember that trials by ordeal were used in medieval Europe and other ancient societies, not just Rome. It was a way of appealing to divine judgment when human judgment couldn't settle the matter. The ordeal might involve holding a hot iron, or putting a hand into hot water, or retrieving something from fire. The idea was that the gods would protect the truthful person and harm the liar. Physiologically, of course, what actually happened was that someone convinced they were guilty would be so nervous and fearful that they'd pull their hand out quickly, burning it badly. Someone convinced they were innocent would hold on longer, minimizing injury. The difference in the burns would suggest who was more confident in their claim. It wasn't accurate as a truth-finding method, but it was brutal, and it was effective as a deterrent. People knew that if their claim was weak, if they had any doubt about whether they were right, they should settle rather than face the ordeal. So the ordeal was, in a sense, a way of encouraging honesty through psychological pressure and physical fear. But not all disputes went that far. Most were settled through the combination of evidence, witness testimony, oaths, and the magistrate's judgment. And there's something almost elegant about that, about a system that relied so heavily on human beings reading other human beings, on the power of reputation, on the weight of community knowledge. Romans understood that people will remember how you behave in a dispute. If you're known for being greedy, for suing over petty things, for being dishonest in your claims, that reputation follows you. If you're known for being fair, for accepting when you're wrong, for being truthful even when it hurts, that reputation also follows you. A magistrate making a decision knew he could rely on the community's collective knowledge of who these men were, what their characters were like, whether they had a history of honest dealing or dishonest schemes. That community knowledge, that reputation, was incredibly valuable information that no amount of modern forensic evidence could replace. Let me tell you about a specific case that illustrates how Romans handled disputes where the law was ambiguous and creativity was needed. This is based on actual legal precedents recorded by Roman jurists. A man hired a worker to build part of his house. They agreed on a price. The worker showed up, worked for several days, then disappeared without finishing the job. The homeowner, angry, refuses to pay. The worker comes back later and demands the full agreed-upon price, claiming he did most of the work. The homeowner says the work is worthless if it's not complete. The magistrate hears both sides. The worker claims he stopped because the homeowner ran out of money and couldn't pay him daily wages anymore. The homeowner claims the worker simply abandoned the job because he got a better opportunity elsewhere. Neither can prove what actually happened. Neither has documentation of this agreement. There are no witnesses to the conversation where they supposedly agreed on the price. So what does the magistrate do? First, he asks probing questions. How long did they work together before the breakdown? How well did they know each other? Did the worker have other jobs he could have taken? Did the homeowner seem to have money problems at the time? He listens to the tone of their voices, watches their demeanor. He might ask other workers in the community if they know anything about either man's reputation. Is the worker known for abandoning jobs? Is the homeowner known for not paying workers? Gradually, a picture emerges. Let's say the investigation suggests the homeowner was indeed having money troubles at the time, that the worker's version seems more consistent with known facts. The magistrate might rule that the homeowner owes the worker something, but perhaps not the full price, because the work wasn't completed. The worker gets partial payment. It's not perfect for either party, but it's a resolution that acknowledges both the work that was done and the fact that it wasn't finished. The key insight here is that the magistrate isn't trying to achieve absolute truth. He's trying to reach a decision that acknowledges the most likely version of events, given all the evidence. And that seems fair given the circumstances. Now imagine a different outcome. The investigation suggests the worker is known for taking jobs and abandoning them, for being unreliable. The homeowner's reputation is solid. His character is good. In that case, the magistrate might rule that the homeowner owes nothing, or owes only a bare minimum, because the worker's own track record makes his claim less believable. Reputation becomes evidence. Character becomes a witness. It's not a perfect system, but it's remarkably effective in a society where reputation actually matters, where being known as a liar costs you business opportunities and social standing. What fascinates me about these cases is how they show that Romans weren't stupid or primitive in their legal thinking. They understood the limitations of pure evidence-based reasoning. They compensated by using tools we still use today, tools that are older than our written legal codes. They read people. They paid attention to character and history. They understood that the most truthful testimony is often revealed not by what someone says, but by how they're willing to back it up, whether they're willing to swear under oath, whether they can get people in the community to vouch for them. These are the foundations of how we still determine credibility. A good lawyer today still relies on character witnesses, on the defendant's past behavior, on whether their story seems consistent and believable. The magistrate in ancient Rome was doing exactly that, just without the modern legal machinery around it. The Romans eventually developed a much more sophisticated legal system, one with written codes, with complex rules of evidence, with appointed judges who were professional legal experts rather than political officials. But even in that later system, the fundamental insight remained. You can't prove every claim with physical evidence. Some matters come down to judgment, to assessing credibility, to weighing the weight of testimony and character. A magistrate or judge has to be able to read people, to understand human nature, to assess whether someone is lying or telling the truth based on subtle cues that no document can capture. It's a skill that takes experience. It requires wisdom. It requires the kind of judgment that you can't write down in a legal code. When we look at how Romans settled disputes without modern tools, we're really looking at a masterclass in how human beings assess truth in the absence of technological verification. We're looking at the raw foundations of justice as a human practice, before it became a matter of lawyers citing precedents and judges reading jury instructions. In many ways, what Romans did is what every judge and jury does today when they have to make a decision based on conflicting testimony. They watch the witnesses. They listen to the tone of voice. They assess credibility. They think about what makes sense and what doesn't. They consider the character and reputation of the people involved. It's psychology dressed up in legal language, but it's human judgment at its core. And maybe that's the real lesson here. In a world obsessed with technology and data and written proof, there's something humbling about realizing that some of the most important judgments humans make still come down to reading other humans, to assessing character, to deciding who to believe when all the physical evidence in the world is ambiguous or missing. The Romans figured that out 2,000 years ago, and we're still using the same techniques today. When we step back and look at the bigger picture of how Romans managed to administer justice across an enormous empire without the tools we take for granted, it's genuinely impressive. They had to solve disputes between people thousands of miles apart. They had to enforce decisions made by magistrates who had no police force in the modern sense, no way to track down people who fled or refused to comply. They had to make the system work across different languages, different customs, different social hierarchies, and they did it by making the system legitimate. People believed in it, not because it was perfect, but because it felt fair, because it involved the community, because magistrates were generally educated, experienced men who had a reputation for wisdom, because the oath and the appeal to gods and the involvement of witnesses created a framework that made sense even without modern technology. They relied on reputation because reputation was all that existed. There was no credit rating. There was no official record you could check. Your reputation was literally what people said about you when you weren't around, so people protected it. They thought carefully about getting involved in disputes because losing a case could damage their reputation in ways that went beyond the immediate decision. A man known for starting frivolous lawsuits would find fewer people willing to do business with him. A man known for being dishonest would be shut out of economic opportunities. The system created powerful incentives for people to behave honestly and to settle disputes reasonably. We've lost a lot of that in the modern world. We have systems, procedures, official records, but we've lost the power of reputation as a governing force. A company can go bankrupt, get bought out, change its name, and essentially escape its past. A person can move to a new city and start fresh, unknown to their neighbors. That's freedom in some sense, but it also means we've lost some of the incentive structures that made Roman dispute settlement work. We've compensated with more rules, more procedures, more written documentation, more professional judges and lawyers. It's not obviously better or worse, just different. But there's something we can learn from how the Romans did it. They understood that justice is ultimately a human enterprise. It relies on people being willing to accept decisions they disagree with, because they believe the process that led to them was fair. It relies on people being truthful, because they know their reputation is at stake. It relies on community knowledge and the power of observation. Those elements are still there in our modern legal system, buried under layers of procedure and professional expertise. Maybe that's something worth remembering. So that's how a Roman lawman, a magistrate or praetor, settled disputes without modern tools. He listened. He asked questions. He examined evidence and witnesses. He read people. He understood human nature. He relied on reputation and community knowledge. He created a process that felt legitimate and fair, even if it wasn't perfectly accurate. He understood that justice isn't just about finding absolute truth. It's about creating a framework where people feel heard, and the decision seems reasonable given the available evidence. It's a lesson that echoes across 2,000 years and speaks to something fundamental about how humans resolve their differences. And maybe that's the real takeaway here. Some of the most important skills for resolving disputes aren't technological at all. They're human skills. Reading people, understanding character, making judgments based on incomplete information, showing wisdom and fairness, creating legitimacy through process and community involvement. Those are skills that transcend time, that work as well in a Roman magistrate's courtroom as they do in a modern courtroom. And in a world that keeps getting faster and more technological and more impersonal, there's something valuable in remembering that sometimes The best tools for finding justice are the oldest ones. A good listener, an experienced judge, a community that cares about truth, a system that values reputation and makes truth-telling rewarding. The Romans built an empire on those foundations, and those foundations still support the weight of justice today.